Serious propane incidents often begin long before the leak, the runout, or the lawsuit. They begin when the company cannot show what was agreed, what was explained, and what was documented. A customer agreement is not just a signed form in a file. In propane operations, it is one of the documents that ties together safety expectations, service rules, and the record of what your company required. When an incident is investigated, the agreement helps show who is responsible for tank monitoring, property access, emergency reporting, and conditions of service. Without that clarity, facts get reconstructed under pressure. That matters for 4 reasons. It affects safer field behavior, stronger compliance discipline, better legal positioning, and a more defensible insurance claim file. This training walks section by section through the agreement language and explains the operational purpose behind each clause in plain language. The goal is not theory, the goal is enforceable practice. And one principle runs through the entire presentation. An unsigned agreement, a vague agreement, or an agreement your field team does not actually follow will not protect the company when it matters most. At the highest level, the agreement documents the relationship between supplier and customer. It explains what service the company will provide, what conditions must exist on the property, and what the customer must do to receive safe service. In plain language, the agreement says this is how propane service will work, this is what we expect from each other, and this is what can happen if those conditions are not met. That may sound basic, but signatures matter because they turn those expectations into documented notice. The customer cannot later say no one ever explained delivery rules, access requirements, or emergency reporting duties. Documentation also matters internally. It gives dispatch, delivery, service, and customer service teams one common operating record instead of 4 different assumptions. From an insurance standpoint, a signed agreement helps show that the company used a structured risk management process instead of informal verbal understandings. That does not eliminate exposure, but it can improve the defensibility of the file. From a legal standpoint, the agreement helps with notice, allocation of responsibility, and consistency of proof. But it only helps to the extent the language is clear and the company actually follows it. That last point is critical. Courts and insurers look past the paper if operations do not match the paper. If the contract requires one practice and the field team routinely does another, the document starts to lose value. So as we move through the agreement, think of each clause in 2 ways. First, what does it say? Second, what must the company do in the field to make that clause real? One of the most important sections in any propane agreement is the delivery type. Usually, the agreement distinguishes between automatic delivery and will call service, and that difference drives responsibility. Under automatic delivery, the supplier is generally scheduling deliveries based on usage history, weather, and tank data. Under will call, the customer is typically responsible for monitoring the tank and requesting delivery before fuel gets too low. In plain language, this clause answers a simple question. Who is supposed to act before the tank runs out? That matters for safety because an out-of-gas event can trigger appliance shutoff, air in the system, and restoration procedures before service can safely resume. A runout is not just an inconvenience. It matters operationally because dispatch, delivery timing, after-hours calls, and customer expectations all change depending on whether the account is automatic or will call. If the file is unclear, the dispute usually lands on your team. It matters legally because clear responsibility allocation can help show whether the supplier or the customer had the duty to prevent the runout. But the clause must be specific, and company practice must match it. The cases show why this matters. In Stibbs v. Mapco, the court allowed negligence issues to proceed where plaintiffs alleged the company did not follow its procedures for an out-of-gas situation. The lesson is not that every runout creates liability. The lesson is that written procedures and field conduct are scrutinized together. A strong agreement also explains that usage can change quickly because of weather, occupancy, or equipment demand. That helps set a realistic expectation that forecast-based delivery is not a guarantee of uninterrupted supply. From an insurance perspective, runout claims become harder when the company cannot show what service model applied, what the customer was told, or whether the company documented warnings and delivery attempts. The operational takeaway is simple. Use clear delivery type language, explain it at account setup, document the customer's selection, and make sure your dispatch and field workflow actually follow that model every time. The leak check and interruption of service section is where customer agreements connect most directly to life safety procedures. This section should make clear that service may be interrupted, and that safe restoration can require access, inspection, and documented steps before gas is returned to use. In plain language, the agreement should tell the customer that if service is shut off, the system runs out, or the supplier identifies a safety concern, the company may need to inspect and verify the system before putting propane back into service. That is not just a preference. It reflects code-centered safety thinking. NFPA 54 addresses interruption of gas service and emphasizes that affected users must be notified with an emergency allowance for notice as soon as possible after shutoff when immediate action is needed. For field teams, that means interruption and restoration should never feel casual. Who was notified, why service stopped, whether access was available, and what checks were performed all need to be handled in a disciplined way. The agreement should also require customer cooperation. If a leak check, pressure test, appliance inspection, or relight procedure requires entry or customer presence, the document should say so clearly. Mendoza v. Easton Gas is a useful example here. That court treated first delivery duties seriously and indicated that when propane is first delivered for a new or existing hookup, the supplier must check lines for leaks. The case also treated a seasonal restart as similar to a first delivery in that setting. The point is not that every jurisdiction will state the duty the same way. The point is that leak checks and restoration events are recurring litigation themes, especially when a system has been out of service and then returned to use. STIBS reinforces the same operational lesson from another angle. If a company has an out-of-gas or restart procedure, people will ask whether the company actually followed it. A procedure that exists only on paper is a weak defense. From an insurance standpoint, restoration of service claims can become high-severity files because they often involve allegations that warning signs were missed or steps were skipped. Good agreement language helps, but thorough service documentation is what gives that language weight. Industry practice supports documenting these events carefully. PERC gas check materials, for example, build customer acknowledgement directly into inspection records. That is a practical reminder that technical work and customer acknowledgement should travel together. The drafting and policy takeaway is to align the agreement, the interruption notice process, the leak check procedure, and the field form. When those pieces fit together, the company is safer and more defensible. Tank placement clauses do more than describe where the container sits on day one. They establish that placement must remain compliant and that later property changes can create new hazards or code conflicts. In plain language, the agreement should tell the customer not to build, enclose, pave around, landscape over, or otherwise modify the area in a way that affects required clearances, access, regulator performance, filling operations, or emergency response. NFPA 58 is central here because container location and separation distances are code-driven. Common training examples include clearance expectations such as 5 feet from the relief valve to an exterior ignition source or mechanical air intake, and 10 feet for certain filling connection and vent arrangements when filled on site. The exact spacing rule depends on container size and installation details, so the training point is not to memorize one number and apply it everywhere. The point is that placement is technical, and later customer changes can destroy a once-compliant installation. That is why the agreement should reserve the supplier's authority to refuse delivery, suspend service, or require correction if site conditions become unsafe or non-compliant. From a safety perspective, this protects against ignition exposure, impaired ventilation, blocked regulators, collision hazards, and unsafe filling conditions. From a compliance perspective, it reinforces that code compliance is ongoing, not a one-time installation event. From an insurance perspective, undocumented site changes can complicate coverage discussions because they raise questions about inspection history, notice, and whether the supplier continued serving a condition it should have addressed. From a legal defense standpoint, the agreement helps show that the customer was warned not to alter conditions affecting the tank site. But again, that language is strongest when the company documents observed changes and enforces the policy consistently. A useful drafting takeaway is to make the clause specific. Instead of only saying the customer must maintain safe conditions, identify examples such as structures, decks, additions, excavation, grading, ignition sources, locked barriers, or vegetation that interfere with code compliance or access. That specificity helps customers understand the rule, helps employees explain it clearly, and helps the company defend why service was delayed or suspended until the condition was corrected. Access to property language is often overlooked, but it is one of the most operationally important parts of the agreement. The company cannot deliver safely to a tank it cannot reach safely. In plain language, this section should tell the customer to keep the route, the tank area, and the equipment clear enough for delivery and service personnel to enter, inspect, and work without unreasonable hazard. That includes practical conditions such as snow and ice, locked gates, aggressive animals, unstable ground, overgrowth, parked vehicles, poor lighting, or any obstruction that prevents a safe approach. This is a worker safety issue as much as a customer service issue. A delivery driver or technician should not be forced to choose between completing the stop and taking an unnecessary personal risk. It is also a documentation issue. If access is blocked or unsafe, the company should record what condition existed, what action was taken, whether the customer was notified, and whether delivery or service was deferred. From a legal standpoint, that record helps explain why the company did not perform the requested delivery or service at that moment. From an insurance standpoint, it shows the company responded to a hazard instead of ignoring it. The agreement can also support a limited right of entry for delivery, inspection, maintenance, and removal activities. That should be described carefully and consistently with company policy, not more broadly than operations actually require. A good operational takeaway is to pair this clause with a blocked access workflow. If the document says unsafe access can stop service, your dispatch notes, driver forms, and customer notifications should reflect that same rule. That is how the agreement becomes more than a contract term. It becomes a repeatable field decision standard. Equipment ownership language matters because control follows ownership. If the agreement clearly states which tanks, regulators, lines, or accessories belong to the supplier and which belong to the customer, field decisions become much easier to defend. In plain language, this section should answer who owns what, who may service what, who may remove what, and where the supplier's maintenance responsibility ends. That matters operationally because technicians need to know whether they are working on company equipment, customer-owned equipment, or a system where responsibility changes at a defined point. It matters for dispute prevention because customers often assume the propane company is responsible for every part of the system. Clear ownership language reduces that confusion before a service issue turns into an argument. Darnell is a useful caution here. That court said a supplier is not automatically an insurer of all customer-owned service piping and may not have a duty to inspect absent reason to suspect a defect. But the court also indicated that when the supplier has good cause to believe inspection is needed, failing to inspect may be negligence. So the lesson is balanced. Ownership language can define maintenance boundaries, but it does not erase the need to respond appropriately when a hazard is known or reasonably apparent. Kelly adds another drafting lesson. Language saying the customer is responsible for certain lines or fittings may allocate maintenance cost or responsibility, but that does not automatically release the supplier from its own negligence. A strong clause therefore helps with authority, maintenance boundaries, and removal rights, while avoiding the false assumption that ownership language alone solves liability exposure. Separate from the delivery type section, many agreements include language limiting delivery guarantees. This section is about uncertainty. Weather changes, road conditions, equipment issues, and sudden usage shifts can all affect supply continuity. In plain language, the clause says the company will provide service in the ordinary course, but it is not promising uninterrupted propane availability under every condition and every usage pattern. That matters because customers often remember the relationship as a promise of heat, not as a service arrangement with operating limits. The agreement helps reset that expectation before a winter emergency or usage spike occurs. From a safety angle, this language supports the broader message that customers must report concerns promptly, monitor their supply when required, and understand that emergency or restricted conditions may delay normal service. From an insurance angle, service interruption claims often turn on foreseeability, notice, and documentation. The stronger the record of the service model, limitations, warnings, and delivery attempts, the stronger the company's position tends to be. From a legal angle, limitation language can help define the scope of the service undertaking, but it will be read together with actual conduct, customer communications, and any contrary promises made by employees. That is why this clause should be supported by policy. If severe weather or blocked roads delay service, the operational record should reflect the condition, the attempted response, and the customer communication. The best use of this section is not to avoid responsibility. It is to state realistic operating limits clearly, so customers and employees understand how service works when conditions are normal and when they are not. That kind of clarity reduces preventable disputes and improves consistency when supply problems arise under pressure. Liability and damages language is often the most misunderstood part of the agreement. Companies sometimes expect a broad clause to eliminate risk, but contract language usually has narrower and more specific value than that. In plain language, these clauses typically try to allocate certain risks, limit certain categories of damages, require customer cooperation, or clarify that some responsibilities remain with the customer. Those are useful goals, but they have limits. Kelly v. Eric's bottled gas service is an important drafting example. In that case, language saying the line and fittings were the customer's responsibility did not clearly release the supplier from negligence. The court emphasized that under Kentucky law, wording must specifically and clearly address that issue. The takeaway is not that liability clauses never work. The takeaway is that vague ownership or responsibility language may be treated as maintenance allocation, not as a waiver of personal injury claims based on the supplier's own conduct. That means drafting must be precise and expectations must stay realistic. The agreement can improve legal position, but it is not a substitute for safe operations, proper inspections, training, or documentation. The same caution applies across jurisdictions. Different states treat exculpatory language differently, so a training presentation should treat cases like Kelly as examples of litigation patterns and drafting lessons, not universal rules. From an insurance standpoint, overconfidence in contract language can be dangerous. Carriers and defense counsel will still focus on the facts of the incident, the applicable law, and whether the company followed its own procedures. A stronger policy takeaway is to use liability language to support clarity, not fantasy. Define responsibilities carefully, avoid vague wording, and make sure the clause matches the way the business actually operates. Good drafting can help. Good operations are what make the drafting credible. Every propane agreement should contain a clear leak response section. If a customer smells gas, hears escaping gas, or suspects a leak, the document should direct immediate reporting and safe emergency action without delay. In plain language, this usually means stop what you are doing, avoid ignition sources, leave the area if needed, and contact emergency responders or the propane supplier right away according to company policy. This clause is first and foremost about life safety. Delayed reporting can allow a small leak to become a major loss event affecting people, buildings, and nearby property. It also matters for insurance severity because delayed notice often makes losses worse. When customers wait, evidence changes, gas migrates, and the eventual claim becomes harder for everyone to control and explain. The agreement should also support supplier access for leak checks and emergency response activities. If the company cannot enter promptly or the customer refuses cooperation, both safety and documentation suffer. This is where agreement language, dispatch procedure, and field forms need to line up. The document should tell the customer what to do, and the company records should show when the report came in, how it was triaged, and what response followed. Cases involving propane incidents repeatedly show that timing, notice, and response actions become central facts. Even when the agreement is well written, the operational timeline is what investigators and counsel will analyze closely. The takeaway is to make the emergency clause unmistakable, easy to explain, and fully integrated into training. In an actual leak event, clarity saves time and time saves lives. The removal and termination section defines how the relationship ends, and that matters more than many companies realize. If ownership, pickup rights, fees, fuel adjustments, and site responsibilities are vague, the final stage of the account can create unnecessary conflict. In plain language, this section should explain when the supplier may remove company-owned equipment, what notice or coordination is expected, how remaining gas is handled, and which costs may be charged if special work is required. That supports operations because tanks, regulators, and related equipment cannot simply be abandoned on a property after termination. The company needs documented authority to recover its assets and close the account cleanly. It supports safety because removal work itself can involve pump-out, disconnection, transportation, and site conditions that need planning and customer coordination. It supports legal clarity because disputes often arise over remaining fuel value, property damage allegations, or claims that the supplier had no right to enter and remove the equipment. It supports insurance position because a documented termination process helps show the company acted deliberately, communicated expectations, and handled the equipment under a defined policy rather than improvised practice. A useful drafting improvement is to be specific about credits, fees, and restoration limits. If the company will restore only the area directly affected by removal, or if extraordinary site work is billable, say that clearly. The broader lesson is that the end of service should be governed as carefully as the beginning. A disciplined exit process protects equipment, employees, customer expectations, and the final record of the account. A well-drafted agreement only helps if the company obtains it consistently and uses it the same way across sales, customer service, dispatch, delivery, and service work. Start by standardizing execution. Decide when the agreement must be signed, what cannot proceed without it, how renewals or updates are handled, and where the signed record is stored for field access. Then train staff to explain the major clauses in plain language. Customers should understand delivery type, leak reporting, access obligations, property modification restrictions, and conditions that can stop service. Next, document exceptions. If a special access arrangement exists, if a customer refuses automatic delivery, or if a site condition requires a temporary workaround, that exception should be recorded and approved under policy. Just as important, compare the agreement against actual field procedures. If the document says one thing and the dispatcher script, driver workflow, or service checklist says another, revise the mismatch. This is where research, code, and claims experience come together. NFPA-driven safety expectations, inspection forms, interruption procedures, and customer acknowledgments should reinforce the contract language instead of competing with it. The strongest companies treat the agreement as part of the operating system. It is introduced clearly, executed consistently, supported by forms, and enforced the same way whether the issue is delivery, access, or a potential leak. Customer agreements are best understood as part of the company's safety system. They document expectations, support code-aligned practices, and help turn critical responsibilities into something the customer has been told and the company can prove. They also serve as a compliance record, a legal defense tool, and an insurance protection mechanism. But none of those benefits appear automatically. They depend on clear drafting, proper execution, and consistent operational follow-through. The strongest takeaway from the cases and code references is straightforward. Documentation matters, leak check procedures matter, clear responsibility allocation matters, and paper that is unsigned, vague, or ignored in practice will not protect the company. As we close, remember this customer agreement training for propane operations was provided by Aegis Risk Engineering as part of our broader safety education program, designed to support safer decisions with customers, in the field, and on every job. This material is provided for instructional and informational purposes only. It is meant to reinforce safe practices and support training, not replace your company's policies, official regulatory guidance, or legal advice. Every organization remains responsible for following the laws, regulations, and internal requirements that apply to its operations, equipment, drivers, and cargo. At Aegis Risk Engineering, our mission is to build a stronger safety culture and improve operational performance with practical, experience-based guidance that makes safety part of the everyday job. We support safer communities and help our clients become best in class by turning strong standards into consistent action across the organization. We're proud to partner with clients through practical solutions, meaningful data, and a shared commitment to building safer operations every day. On behalf of Aegis Risk Engineering, thank you for your time and attention, and for the work you do to keep people, loads, and roads safer. Use your agreement as a working control document. Review the language, train to it, document it, and enforce it consistently in the office and in the field. When that happens, the agreement does what it is supposed to do. It helps prevent incidents, supports compliance, strengthens defense, and protects the business when pressure is highest.